take us through the thinking of extending the maximum sentence on inciting genocide to life in prison? Is that too much?
What I would say to you is that we put a lot of thought into many aspects of this bill. There's an aspect that deals with the commission that's being created, and there's aspects that deal with the criminal law. We are creating a new freestanding hate crime offense. We are enhancing the penalties, as you mentioned, for the hate crime offenses that exist currently. And we're also ensuring that a peace bond could be procured for somebody who there's a reasonable likelihood will create a hate crimes offense. With respect to genocide, what I know as a lawyer, as minister, and what I've learned from the stakeholders and the experts whom we have consulted is that there is a determination to demonstrate at the highest level that the maximum penalty for a crime such as advocating or promoting genocide should be increased. That penalty, as it stands right now, when you proceed by way of what's called an indictable offense, is 5 years. We are saying that at a maximum, that should be elevated to 25 years. There will remain a range that's available to the judge that is disposing of the case. That is a range that it can reach as high as 25 years. It will depend on the context, but there is no doubt in my mind, particularly now where we are as a country, that people who advocate genocide need to understand that that is a very serious matter, and that is a matter that could be penalized at the highest level.
How did you determine the 24-hour takedown rule would only be for child sex abuse images as well as the non-consensual sharing of images? Like, how did you kind of arrive that those two were the ones that you keep that in there for?
Yeah. So we literally consulted upon this, and you and other journalists in this room have asked me, Minister, where's the bill? You've been working on it for a long time. And you're right, we did work on it for a long time because we had to get it right. So we heard from those extensive consultations over literally years about the different types of content that we need to address, and there were 7 in total. And what we heard is that you need to look at international examples. Australia had tried a takedown provision across many types of content. Germany had done that across the board. They've since resiled from that and moderated their position to move to what's called a risk-based analysis. But what we heard is that we need to address certain types of content, but for the 2 that you mentioned, the issue of child sexual exploitation material and the non-consensual sharing of intimate images, what is known as revenge porn, so that we can be clear with Canadians, is that there's no space. There's no tolerance in the public domain for that kind of material, and that kind of material needs to be brought down immediately.
Private messages, Discord, Snapchat, WhatsApp, and a lot of AI deepfakes or non-consensual images are shared there. Are you going to miss a lot of this because of that provision?
So what I would say to you is that, first of all, with respect to deep fakes, we thought about this, and in the intervening 2 or 3 years when we've been discussing and consulting about this, the emergence of AI has literally come to the forefront, showing how dynamic the internet is. And what we've done is we've legislated specifically in this bill the notion of deep fakes being included specifically in the context of intimate images that are being shared without consent. For the Canadians that are watching, think about what transpired 4 weeks ago with Taylor Swift. It's her head superimposed on a nude body. That is the same essence of what we are trying to address. We will address that, and that is included in the legislation. With respect to your specific question, what I would say to you is that we heard about the nature of what had been done in some of those other countries that moved earlier than us on this very issue. And what we heard loudly and clearly, specifically in the context of the British debate that related to encrypted communications, is that they wanted to pierce that type of communication and address even that through their online safety bill. And they received a lot of negative feedback about the specific challenge that could have for freedom of expression. What I would say to Canadians that are listening right now is that I have listened. Our government has listened. Where we were 3 years ago, to Stephanie's question, is that we were in a different spot where we thought we would identify categories and have takedowns across the board. What we've done is reflected on that, on the critical importance of enhancing freedom of expression and promoting freedom of expression and ensuring that we calibrate this, and we are doing this now in a very measured and appropriate manner that addresses the harms as we see them, but ensures that Canadians' private communications will be exempt from this legislation.
Crime offence, if you could just clarify, I mean, it comes with a potential penalty of life imprisonment. Could you just clarify for us how that would work? I mean, what kind of offences do you envisage could carry that kind of offence? And are you saying that it's no longer an aggravating factor, that it could be a standalone offence? But could you give us some examples of that?
Okay, so in terms of the second part of your question, we're not eliminating the aggravating factor.
Right.
But what we are doing, it's a little bit easier for me in English, what we are doing is creating a freestanding hate crimes offence, which touches any possible delict or crime under the Criminal Code of Canada. And I think what is important about it is that it gives the police, and it gives prosecutors more flexibility in terms of contemplating this aspect on the front end of their deliberative exercise, on the front end of how they will conduct their prosecutions. Very importantly, this does not require AG consent. The other hate crimes components, promoting genocide, willful promotion of hatred, things like the anti-Semitism and Holocaust denial offense, require the Attorney General's consent, as does the peace bond that I just mentioned. This provision is something that can be laid it can be initiated on an arrest warrant by a police officer and continued by the Crown, absent the consent of me or a provincial Attorney General. That is very, very important in terms of giving more tools to law enforcement, but secondly, it's important for denouncing what we are seeing right now. And that is critical. Everything you've just heard from people like Carla, everything that I have heard over the last year is that hate is on the rise in this country. We need to be providing more tools, not less, to denounce the hatred that we are seeing, and this will do exactly that.
I don't understand how you envision setting up this new digital services office, ombudsman commission, and keeping the partisanship out of it, because some critics will automatically say, well, this is the government gets to pick who's going to be, it's going to be David Johnston, the special rapporteur, all over again. What are you going to do to forestall that and deal with keeping partisanship out of this?
No, thank you, Stephanie, for the question. I think it's important. So it's a digital safety commission, it's a digital ombudsperson, and it's a digital safety office. So there's three sort of components here. But what's really critical is that they're going to have expertise. They're going to be able to deal with this in a dynamic manner. The internet is constantly changing. But very importantly, to your point, I know that we need to both establish this, but we need to have Canadians confident in how it's going to work on the ground. And what we've specifically entrenched in the bill itself, I'd urge you to look at it closely, is that the chair of that commission, the head Digital Safety Commissioner of Canada, will be decided in the chamber that is right below us. It'll be voted on in Parliament, in the House of Commons, and in the Senate. We want Canadians, through their representatives, to have a say on who that person is, to have confidence in their ability to execute that function. It is a critical function. I appreciate that. We are being very careful and measured in how we are approaching this and how we are working to ensure Canadians' confidence in that. If there are other measures that work towards enhancing Canadians' confidence in this institution that's being created, I hope that comes out in the parliamentary debates, in the committee study, in the Senate's work on this bill. It is critical that we get this right and ensure that confidence.
Minister, is this new standalone hate crime is that enough? Does there need to be more help for more support for law enforcement to tackle this sort of thing?
I think we always need to ensure law enforcement has the assistance to do this. There's a person behind me, Mohammed Hashim, who's right here on the right, and he has been doing incredible work with the Canadian Race Relations Foundation on just laying out what constitutes a hate crime. There are hate crimes units among certain police forces in this country. In my view, there are not enough. What is critical in this legislation is that we are also entrenching a definition of hatred, which is critical. People say to me, well, Minister Vrani, where did that definition come from? Is that something you guys just developed behind closed doors? Categorically not. That definition of what is hatred, what arises to the level of hatred, comes from Supreme Court jurisprudence that dates back to 2013 and cases before it. The Supreme Court has outlined that what we are talking about is detestation and vilification of a person or a group. We are not talking about stuff that some people call awful but lawful. There will still be humiliating comments. There will still be offensive comments, insults, expressions of disdain and dislike. There's a lot of stuff that is out there that will remain out there. But when people arise to the level of detestation and vilification, law enforcement, and they asked me for this when I was consulting on this literally 3.5 years ago as David Lametti's parliamentary secretary, they said we need clarity on the definition, as well as some of the things that you're asking, that you're putting on the table. What they also said to me is that prosecutions take time. So I'm being very candid with you. There are people that will pursue that criminal remedy, but for some people, some of the people that are right behind me, like Jane, who you just spoke to, what they want is for the material to just come down, right? They just want that stuff off of the internet. What we are doing is at the same time, we are addressing Canada Human Rights Act tools, criminal code tools, and tools through the new Digital Safety Commission that will help get this material out of public circulation, which is desperately what people need, especially our children.
You've removed hate speech as one of the categories of content. So to Stephanie's point, how are you going to be you're not going to be regulating that because you've just taken it out of the 7 categories of content that you're going to be regulating social media companies to police.
So what I'd say to you is that there are 7 categories across the board that constitute harmful content. That is incorrect. Content that foments hatred is one of the 7 categories. Okay, but to your point, Stephanie, that is not one of the immediate takedown provisions. That is correct. But there are still aspects that empower users. I'll give you some of them. Okay? If you are affected by what you think is content that is fomenting hatred, that meets that definition, what you can do is you can flag that content to the platform. One route. Second route is you can flag that content to the Digital Services Commissioner, and they can seek some response from the platform. The third route is that the platform, pursuant to this legislation, is going to implement a digital safety plan that talks about risks that are out there, what we're doing to reduce those risks, and they're going to be held accountable for what they are doing or not doing to reduce those risks themselves. If there is a situation where they're not abiding by the rules that they have set up for themselves, they can be subjected to penalties, and the penalties are significant. You heard me just touch on this in my comments. Those penalties touch as high as 6% of global revenue or $10 million, whichever is higher. That is a significant message to the platforms in Canada that their profit imperative solely cannot drive what is happening in Canada any longer. Safety has to be part of the equation, and we will ensure it is through penalties of that nature. Thank you very much.